Hi, welcome to our monthly meeting, the IGDA Des Moines chapter. I am super excited to be with you all again. Once again, streaming. Still can't wait for us to get together and be able to have a physical presence, but we'll be getting to that pretty soon, right? Let's hope for 2021. In the meantime, again, I'm Brian. I am here to lead us right into our presentation, go over a few of the things about how to get a hold of your Des Moines IGDA chapter, and of course, stumbling over my words this morning. So it's going to be a great night. Just to give you a quick reminder of who we are, we're the Des Moines IGDA chapter, as I've said about 5 times now. Our goal is to connect individuals, help individuals get jobs, help you make your passion into reality, both in the digital and analog game side. We meet on the third Tuesday of each month, right here on YouTube Live again until we're physical. We're talking everything from last month we had audio. This month we're talking about IP law. So we want to make sure that we cover as many topics in the game development realm that you look forward to, that you're interested in. So if you have any ideas of any topics that you'd like to hear, hit us up on our Slack channel. Our Slack channel URL, you see it. Let's see, you can see it on one of these sides. Hit us up on Twitter if you'd like to. We're not very active on Twitter. We are more active on our Facebook group, our Facebook page. Slack is where you want to be. So I would highly recommend hopping on our Slack channel. And also as an invitation, after our session today, Brett said he does have another engagement right after, but here in a little bit, Brett will be open for answering any of your questions, and of course over the next couple days or however long you decide to stay active for. So hop on our Slack channel. Also, go take a look at the Discord server for IGDA or for the mothership. Go get the latest on any of their Twitch streams that they're doing, any announcements that are happening. And lastly, if you're interested in becoming an IGDA member, feel free and reach out to one of us. There are a lot of additional benefits that are provided with it, such as knowledge in the communities, so IGDA Expert Resource Library, special interest groups, countless others. Again, reading from the slide, lots of discounts, lots of benefits through um, different things out there. Again, as a Unity advocate myself, you do get a discount on Unity when you get a membership. If you're not interested in a membership right now, do keep your eyes open. If you just like to try it out for a month, they do have discounts that happen periodically. One of the bigger discounts happens around Global Game Jam, which hopefully early next year we'll be able to talk about Global Game Jam and how that's going to happen. So link is right there for if you'd like to get a membership. Otherwise, without further ado, um, I have Brett here, who is really interested in talking to you. Brett Trout. He is an Iowa, uh, let's see, an Iowa patent lawyer. So Brett is going to be talking with us about patents, trademarks, just how to protect your property, how to make sure that no one else is going to come in and snag your stuff. So Brett will be just right back. There
Sorry
he
about
is.
that. Had,
Hi, Brett. Welcome.
had the security guy come in the office, wanted to make sure everything was okay. So yeah, how's everything?
Amazing.
So
So,
great.
and one other thing, I apologize right before you start. If anyone does have any questions, please feel free and put them right into the live chat. We will be interrupting Brett along the way, hopefully not as abruptly as we did before. But feel free and put your questions in there. And he said he's very excited about hearing from you.
Great. Well, I appreciate it very much. And I just need to put a disclaimer up front that this isn't legal advice and I'm not your attorney. So I can only give general legal information. And if you have a particular legal question that addresses specific legal issues, you're going to have somebody talk to you specifically about that under a confidentiality arrangement. I kind of like the subtitle of this talk would be "Great Artist Copy" or "Good Artist Copy, Great Artist Steal," and that's the thing is everything's already been invented, and so anything that you're going to put together, anything you're coming up with, whether that be a design element or some piece of software, you're just basically reconstructing things that have been out there and putting it in a new form. And then once you have it in that new form, that can be protectable in terms of patents or copyrights or trademarks. And we'll go into each one of those, what they do and what the value is. But it's important to really know what those different categories of intellectual property are, how to protect them, and make sure that two things: one, that you have the right to do it yourself, and then the other thing is if somebody else does it, can you stop them from using it? I don't know if you wanted me to kind of just go into the different types of intellectual property now, or uh,
Absolutely.
okay. The first type of intellectual property we talk about is patents. Patent is basically just a piece of paper. If you get a patent, it just looks like this, has a little cute little ribbon on it. And if you go on to Google patents, you can search for any patent in the last 50 years. It'll come up and it'll just show you what we have here. It gives you the name of the number of the patent, which is how you're going to identify it. It'd be either a 7-digit or an 8-digit number, the date that a patent was issued, who the inventor is, and who actually owns it. So the patent has to list who the inventor is, and that's not something that can be fudged with at all. It has to. You can't just put the CEO's name on it. It has to be the person who actually invented it, and then the person who owns it would be, in this particular case, it's Electronic Arts, and they would own everything. Probably the inventors don't own anything at all because they've assigned all their rights to Electronic Arts in that case. It's a it's very difficult to read what a patent is, but the parts are basically the informational part, which has all the inventors' names and when it was issued, uh, and then it'll have a bunch of drawings associated with it, and those drawings will obviously vary according to what kind of program it is. For this one, it's a touch screen device, so it's going to have drawings of a figure on there, and then basically you're moving the touch screen to move the figure. The invention will be described, a little bit of background, what the field is like, and then it'll have a summary what the invention is. Then it'll have discussion of what the figures mean, and the majority of the patent is this detailed description, and it just anybody should be able to read that and determine what the product actually a patent would be claims, and that's going to be a one sentence description of what the invention is. What you're claiming is your meets and bound of the invention. And so this one sentence basically goes from here all the way down to here, and then all the way down to here. There's some of them that are 3 or 4 pages long, but basically the take home here is the patent is protected by the claims. And when you look at the claim, it's a one sentence description of what the patent covers, and it's a collection of items. It's A plus B plus C. If I had a patent on a chair, it would be a seat, a leg, and a back. It's not going to say 4 legs. It's not going to say 3 legs. As long as you have each one of those things, then you infringe that patent. So if you had a three-legged chair, you still infringe because you have a leg, a seat, and a back. Now, if you made a stool without a back, so if you eliminated one of those things, then you don't infringe. So if you're looking to get around a patent, the thing you want to do is try to take that claim and eliminate one of those things. People think, well, if I just put an extra bolt on or an extra bell or whistle, then I avoid infringement. You can put as many additional things as you want, it still infringes. You need to take something away. Very counterintuitive, but you look at that list of items, take one of those items out, and then you don't infringe. Now, it gets a little dicier than that because, if you take that item out and then put in a similar item, that may or may not be an issue. You just have to look at what it is. That's for video games. That patent was a 25-page patent because there's so much detail and so many things you want to get around it. For a board game, you're probably looking more like a 6-page patent. This is a 1923 patent for Monopoly, and the take home there is, the one sentence description is just this one little paragraph right here. So board games, it's a lot easier probably for the average person to read what it is and determine it. But even I, doing it for 30 years, I'm going to read the claim in that video game patent, and I'm not going to understand what that is. I'm going to need to read that language there and then read the specification, the detailed description, and make sense of what I'm reading. Because when you read a patent claim, and if you're having a patent on a car, it's not going to say a hood and a trunk and a frame and a wheel and a steering wheel. It's going to basically say um, this steering wheel's coupled with this link to a transmission, or the steering wheel is connected to the drivetrain or the steering column, and so it's only going to talk about a little bit of it, and it's not going to talk about all this extraneous stuff. Because once again, we talked about it. The more stuff you put in, the easier it is for somebody just to eliminate one of those things and go from there. So it won't make sense if you're just reading the claim. You need to read the specification by itself. In terms of what you would want to get patented. You want to, for a board game, you're kind of looking at the mechanics to get patented. And for a video game, you're looking at any of the functional aspects of it. So patents just cover the functional aspects of your game. And it covers basically any way of doing that. So if you have A, B, and C, like if I have a seat, back, and a leg, if I have wooden legs, if I have ceramic legs, if I have metal legs, all those things are covered if I didn't specify them. So you want to keep it as broad as possible. Board games, I filed board game patents, and you can get patents on board games, but it's, first of all, it's very expensive. You're looking at probably $10,000 to $15,000 for a very low end patent on a board game. A lot of board games don't make that much money to begin with, so you're basically giving all your profits to the patent attorney. The other thing is, unlike almost any industry I've ever worked in, board games have a kind of a self-policing system where if someone tries to knock a game off, then the community comes together and rallies behind that designer and tries to make sure that everyone boycotts that infringing game. It's happening. There was a game called Goat Lords, which was basically just a reskin of a game called Cover Your Assets. And if you look on Board Game Geek, the reviews are terrible because they're just trying to drop it down so nobody buys the knockoff. There was another game, Alien USCSS Nostromo, which was a knockoff game. And that game actually was a very complex game, and it was picked up by a publisher, and it was going to get published. And I believe it was something along the lines of uh, Nemesis, like it's an alien thing where you're going through the ship cabin and aliens are attacking you. But that got decimated. It ended up with a Board Game Geek rating of 1.2. I'm sure it's a great game, but they just didn't like the fact that they had stolen it from somebody else. So in the board game area, you probably don't need a patent. In the video game area, you definitely do, for a couple reasons. One, to keep people from stealing what you have. The other thing is it acts as a trading chit in case of somebody suing you, and money doesn't really mean anything to them, but they really want a license of that patent that you have. So you can just give them a license where money wouldn't work at all. So it gives you another avenue to get out of trouble when you get into it. Patents are good for 20 years from the date you file it. The important thing is unlike other types of intellectual property, you got to get to the patent office as soon as possible. It's a race to the patent office. Whoever files first, gets the patent. So you want to make sure that you get there before anybody else. The other thing is, if you tell anybody about it, you have 1 year to get a patent on file in the United States. If you don't, it goes in the public domain. You can never put the genie back in the bottle and get a patent back. And Europe, some countries don't even allow you to get patents on board games. Some are very sketchy on what you can get in terms of software for video games. But though, again, if you get your patent on file in the US, then you can use that as a preservation date or a priority date for getting those filings in Europe. You'd have to get those on file within a year of when you file the US application. If you know you're going to go in Europe from the start, you can file a different procedure. But usually people just start with the US. But again, for a board game, you're probably looking at 10 to 15,000. If you're looking for a video game, you're probably looking at, you know, 20 to 25,000. And it depends if you're just looking at one little part of what you're trying to protect. You got to file a different patent for each invention. And that's just not something patent attorneys came up with. That's something that the patent office requires. Sometimes we file it and the patent office says, hey, you tried to squeeze too many in. And at that point, we just break them off. And so you end up with 2 patents or 3 patents, and you're just going after those all at the same time. Patents last, they can take about 3 years to get, and they're good for 20 years from the date that you file it, assuming you continue to pay maintenance fees. The problem is, again, the average cost for filing for getting a patent lawsuit, if you're going to sue somebody for patent infringement, just the attorney fees, just the amount you're going to pay your attorney to go through a jury trial is $2.5 million. That's, yeah, it's probably probably not. I mean, we do it for less, but the reason it's 2.5 million is 95% of patent infringement lawsuits settle out. So they don't go into that $2.5 million number. The thing is, the two sides kind of butt heads for a while and exchange information. One side sees the writing on the wall and they settle. So 95% of them settle. You don't want to be that group that goes into the 2.5 million, because if you go and you win, you've spent that 2.5 million and there's no guarantee that you're going to get it. So you have a $2.5 million judgment against the other side, but they just spent their last $2.5 million on their attorney. So they don't have any money left. So you have basically what's called a judgment proof defendant. You're never going to see your money. Uh, all kinds of intellectual property have special provisions to help the little guy. So if you show that the other side was willful, you can get triple damages and attorney fees. So if you were to get $1 million judgment, that could be a $3 million judgment. Plus, they'd have to pay your $2.5 million in attorney fees. So it's kind of a game of chicken that you're trying to show the other side, we're going to go the whole way and you're going to lose. So you might as well pay us up front. A lot of big companies say, well, you don't have $2.5 million to get to trial, so we're just going to bully you. But you can do things where you can work out an arrangement with your attorney where it's a contingent fee. You don't pay any attorney fees unless you win. And the great thing about that is it convinces the other side you're going to get to trial. So they're going to settle out with you and they're not going to go to trial in the first place. Because that's the key to winning intellectual property, is not going to trial. If you've gone to trial, something has gone horribly awry. You want to basically convince them that if you go to trial, you're going to win, so they should pay you up front. So what we're looking at in terms of that's basically the breakdown for patents. Patents don't allow you to do anything. They only allow you to prevent other people from doing things. And again, that's kind of a counterintuitive thing. We call people up all the time, send them a cease and desist letter. Hey, you're infringing our guy's patent. And they come back and they say, well, we have our own patent, so we don't infringe. The patent office giving you a patent doesn't mean you don't infringe anybody. If I came up with a chair, and then Brian came up with a rocking chair, and he tried to file it, the patent office would say, yes, 100% it infringes Brett's chair, but we're going to give it to you anyway because it doesn't give you a license to make it. It just allows you to stop other people from making it. So if I got the chair patent and Brian got a rocking chair patent, neither one of us could make the rocking chair, because if I made it, it infringed Brian's patent, and if he made it, it would infringe my patent. So the reason you do that is you work out some kind of a licensing deal where he pays me a little bit of money and then he gets to make his rocking chair, or I buy his rocking chair patent and then I make it myself. So those are the kind of the counterintuitive things are the take home I want for today. A patent claim, when you read it, if you go to Google patent and you look at any patent you want to look at, what you're looking at is that claim. It'll have a number one on it. And then you're looking to try to eliminate at least one of those things in that collection of things under claim one. The other thing is that a patent doesn't give you a right to do anything. It only gives you the right to stop other people from doing something. The next area that I think is very important for any type of game designer or company that's invested in games is trademarks. And that can either be a logo or a word, but it's basically something that you put along with your game or your service or your development graphic design services, and that associates that with that particular logo or that name. And the crazy thing about patents are you want to get the patent on file before you start selling it so it doesn't get out there. With trademarks, you kind of want to start using it and then register it because you don't have any rights. No one has any rights in a trademark unless they're using it. There's no such thing as what's called naked trademark rights. You only get trademark rights that as they're applied to a particular good. If you stop using it, then the trademark goes abandoned. Someone else could grab it up and they take it away from you and you can never get it back. So trademark rights are only associated with use. Now, if you're thinking about doing a trademark and you're going to do it in the next 3 months, we can file an intent to use application. That's basically calling dibs on that. And if you go through the whole process and you get it, the Patent and Trademark Office says you can have that trademark registration, but you do have to start using it. So the second you start using it, file a piece of paperwork, and then all of a sudden you get your trademark. So again, even though we file it, the intent to use, you don't have any rights in it until you actually start using it. Basically, what you're looking at for something, the trademark rights last forever as long as you keep renewing them. They usually cost about $1,000 or $2,000 to get. It takes about 6 months to get. If you're going to sue somebody over it, you're looking in the $90,000 to $100,000 range for a trademark infringement lawsuit. So, and those things always kind of balance out too. There was a company that wanted to have an online Facebook game and they called it Scrabulous. And obviously Scrabble didn't like that. So they sued him and they went back and forth. And actually they ended up having to change their name to Lexulus, and then ended up not making any money. And then actually Words for Friends came on and that got really big. And so Hasbro actually licensed from Word with Friends so that Hasbro could make a board game out of that. So it's the reason I brought this case up is that Hasbro came up with the game, and Words with Friends basically took everything from that game. And the only thing Hasbro really had in that game was the name. Words with Friends didn't use that name. And then Hasbro had to license back from Words with Friends to make their board game version of it. So Words with Friends basically stole Scrabble, and then Scrabble had to license it back from them and make a video game. Trademarks are pretty straightforward. You'll get a pretty good idea of what you have and what you don't have right away, whereas patents can take 3 years to go through. Next thing is copyright, and copyright is kind of the opposite of patents. Patents protect things that are functional, and then copyright protects things that are aesthetic. By definition, copyright can't protect anything that's functional. There's a type of a patent called a design patent, and that's basically what a copyright is. A design patent just protects the aesthetic elements, the look, how it looks and how it feels. It doesn't protect anything in terms of functionality. The copyright lasts for however long the author lives, plus an additional 70 years. That usually changes whenever Mickey Mouse comes up to go in the public domain. They pass another law and then extend it out. So it was never supposed to be life of the author plus 70 years, but it just keeps getting extended out. You're probably looking at about $200 to get a copyright registration. It takes about 4 months to get, and you're only looking at about $60,000, $70,000 if you want to sue somebody over it. The thing is that the reason it's so cheap is, unlike patents and trademarks, when you file it, they go and they look and see, oh, is it similar to these other patents or similar to these other trademarks? Copyright, they don't care. They just file it, because if I could come out of a cave and say, hey, I've been in this cave for 75 years and I wrote the Foundation trilogy, word for word, I could go get a registration on it and I would have my own copyright in it, because copyright doesn't require that it be unique. It just requires that you be the original author of that. And so Patents, you have to be unique. Trademarks, you have to be unique in that one little area of whatever your service is. Copyrights, you don't have to be unique. Now, that wouldn't happen. I mean, it'd be very difficult for me to prove that I wrote the Foundation series word for word and I didn't see or have access to the original books, but technically you could do that. Those always fail when it comes up and they say that it's something original and it's not, because it's difficult to prove that you were the first one to, or that you didn't have access to the original piece. Interesting thing about copyrights is um, plagiarism is not illegal. Plagiarism is different than copyright infringement. Plagiarism is that you're stealing somebody else's idea, and then that kind of goes back to that Picasso quote that I had at the beginning. That good artists copy and great artists steal, and it's basically that if you're stealing somebody's idea and then you put it into your own reduction of practice, so you're actually take their idea and make a game out of it, or take their idea and make this software module out of it, that's going to be okay, because ideas are not protectable. What is protectable is the actual uh, when they actually have the product put out there. So if somebody has software code in their module and you copy that software code, that's copyright infringement. That is illegal, and you will get shut down. Somebody has a design for their board game, and you take that board game design, you will get sued for copyright infringement. You'll lose, and that is illegal. You could be actually subject to criminal penalties, if you're doing it enough and you're doing it so openly that it causes the authorities to get involved. So there are criminal penalties for copyright infringement. But if you take their idea and then reformulate it as your own, make your own design board, your game board, your own software module, your own software architecture, that's not going to be infringing. Plagiarism is, if I plagiarize something, then I could get disbarred. If you were at school and you plagiarize something, you could get kicked out of school. It's more of an ethics thing. And if you're subject to some ethical restraint, like your honor code in school, or if you're the bar associate with an attorney, they can strip you of those, but there wouldn't be anything where you would go to prison for plagiarism. Um,
Do have a
the
quick question for
Sure.
you, Brett. So we have a question that came in from looks like Artillery Studio, and the question was: I began working on my game at the end of last year, and need to know if they should be getting the name copyright protected or not. Also, they mentioned they have a website domain purchase. So what I'm hearing from what you're saying, Brett, is if you have an idea, you have something formulated that would be patent worthy, look into getting a patent early so somebody else doesn't. And then anything else, it just seems like do it often and early and often. Does that sound about right?
Right. Yeah, definitely. If money was no object, you always want to do that as much as possible, because I could always use another jet ski. But I think if you're a small company, you really have to look at what your budget is, and go that you have to look, 9 moves down and see what's going to happen. So maybe the company could spend $25,000 on a patent, but do they have a program in place for getting that jury trial with the patent? And if you don't have somebody that's going to, do it on a contingent fee basis, I mean, there is a little bit of a scare tactic where you have scare people off for a little bit, but unless you have a program to get it done, I think that might be more for a larger video game company. But exactly what you said, do it soon and do it often. That's a really good idea for trademarks and copyright. So if that question was about a name, certainly I would think about getting it copyright registered or a trademark registered for the name, because even though the trademark registration doesn't give you a right to use that name, if you have that trademark registration for 5 years, you can file a notice of incontestability, which means, hey, everyone in the country has been on constructive notice that I own this trademark for 5 years. So if you did have a claim against me, as a speak now or forever hold your peace. And so now I do have this shield, as opposed to just having the sword where I can go after other people. It is a shield that is defending other people against me getting sued for infringement. The way trademarks work is it always goes back to whoever used it first, and it is only related to that particular area of commerce. So if I register a trademark Apple for records, then somebody else can later come along and register Apple for computers, because those are completely distinct areas. Not not knowing that pretty soon they're going to be exactly the same areas, and there's going to be a big fight when Apple records and Apple computers, start talking about iTunes. Then it's a major problem. But It usually goes back to whoever used it first. But again, this registration aspect gives you that sword and the shield once you've had it for 5 years. So it's super important to get it done early. Was that their question related to the name?
It was about the name. Yeah, absolutely.
Okay. And if there is any kind of copyright elements of it, it's very, very important if you're a company producing anything, video games or board games, that you get an assignment from anyone involved. If you say, "Hey, I'm going to give you $500 and then you make this logo for me," you don't own that logo, even though they produced it because you told them to do it. They still own the logo. You just have a right to use it for a limited purpose. We've had that case arise where someone sued our guy for copyright infringement for using their logo. And then we went and found the woman who actually created the logo, and we got an assignment, a copyright assignment. So we actually owned the logo and they only had a limited right to use it. So we bartered that back and forth and worked out a deal that we would never have gotten worked out if we wouldn't own the intellectual property. Had that person from the start had all their ducks in a row and gotten an assignment of all the copyright in that material from that designer, they would have not had any kind of problem. So you need an assignment from everybody who comes up with any kind of uh, copyrightable work, whether it's a design element or any kind of copy that they write for you. And then you need an assignment for all the software programmers and for all the inventions that they would come up. So the software programmers have to assign the copyright in the code and any inventions in that code to the company so that the company can file it. Those are probably the biggest take home for the whole day that we're talking about this is if you own a company, you need to have anybody that works for you or does any work for you sign a copyright assignment, basically an intellectual property assignment, so you get the patents and the copyrights. And if you don't do that, you're just going to end up in a world of hurt. Because if you enlist them to produce something for you and say, how much is it going to cost? They're going to say $5,000. And you can say, how much is it going to cost if I have you assign all the rights to me? It's still going to be $5,000. But if you do it and you don't get that assignment and you come back 3 years later and you say, how much is it? They're going to say $50,000 because they have you over a barrel. There's nothing you can do. Whereas if you do it right up front, it's not going to cost you any additional money. So that's a good way to get ahead on that. If you can if you can spend any money on anything, I think it's trying to get that copyright assignment so that you own all your intellectual property. If you're going to be a potential target for somebody to buy you out, they're going to want to make sure that you own everything. And if there's some kind of holes in your intellectual property, that's just not going to be something they're interested in. It could blow the whole deal. You can scramble around and pay that person $50,000 to give it back to you right away, but that might be too long and it might blow the deal. So you need to get all those things, all those ducks in a row before you make a move at all.
Yeah.
Yes, exactly. That is a contract that has to be, basically customized to what exactly you're doing. So it has to say who's doing it, what they're doing for you, and then the intellectual property that's going to be transferred. And you really want to identify that really well. So if it's a, software they're producing, then you can attach, um, you know, a thumb drive or some way to identify what that software is that's being transferred. You don't want any kind of usually what we say is that you're doing this XYZ project, then all the work that you do is going to be transferred to the company. And, you know, uh, you're basically giving a complete assignment and you're also given a warranty too that you want them to warrant that they're not giving you anything that's infringing because sometimes what people would do is they're going to put up a really uh, efficient piece of code and they're saying, hey, this is free and anybody can use it and put it into their software program. And then they pull that down and then somebody puts it in their software program. They come back later and say, hey, you stole my code. And they're saying, well, we got it off a site that said it was free. And they're like, well, I don't know who that was. That wasn't me. You got to pay me. I either get to shut down your whole program or you pay me a license fee. And they basically have you over barrel at that point. So yeah, that's a good point. It's a contract that you got to have executed right up front.
So that's actually a really interesting thing there, Brett. And along the lines of software, so I write software all day. We pick up a lot of dependencies from npm or any other package management solution, and usually they have license that are packed away with them. Or we can even talk about Unity, the Unity store. How do we know? I guess with what we're picking up, which specific types of license we should be looking for. I think there's like the MIT license. There are other different types of license, and along that journey, what was that other one? Creative Commons. So along those lines, should a studio be capturing that information and providing it to an attorney, a lawyer, or somebody who's a lot more, I guess, knowledgeable over the lingo, just to make sure that they're protected, that their software game is protected?
Yeah, I think that's a very important point is that if you're using these, some of these open source licenses, you make sure that it allows you to do what you want to do. If you a lot of them, there's a bunch of Creative Commons licenses from things that say that you can use it with attribution, or you can use it with as long as you don't do it for anything commercial. uh, a lot of people think this goes back to the plagiarism thing, that if I use it and then I give them credit for it, then I'm not going to have a problem. And all that does is get around the plagiarism thing, because you're not stealing their idea because you're giving them credit for it. But again, we don't care about plagiarism, we only care about copyright infringement. And so you want to make sure that it's tough. What I'm going to say is you want to make sure you have the kind of license that you want, and that goes back. It begs the question: what kind of licenses do you want? And it kind of depends on where you see this going. I mean, are you doing it for another company? In which case, you have to make sure that when you sign the contract with the other company that says I own all this and I'm giving it to you, you carve out that and say, oh, I'm giving you everything I'm writing. It also includes this part of the program, which is under an MIT license, and you have to agree to that. Because if you sign an agreement to develop something for somebody else and you say that you own it, and it ends up being an MIT licensed product, then you're going to be in big trouble. They're going to sue you. And anytime you get sued in this arena, it's probably going to max out whatever resources you have. So it's just going to be very problematic. So if you're working for a company, you're putting it together, you definitely want to make sure you have all those licenses, and you want to make sure you have the licenses that you need. And I just can't tell you what those licenses are, because it really depends on you as a company, what you want to do. If you're doing everything internally and no one's ever going to see your source code at any point in the future, and you absolutely know that, then it's a different ball game than we're setting up ourselves for acquisition, and they're going to go through every one of our licenses with a fine tooth comb, because they're going to spend at least $250,000 on due diligence, just making sure that either everything is in there, or you're signing your life away to say, if it isn't, then you can take my house. So you want to make sure you do it good from the start. And if you do it right from the start, it's very easy and very cheap. Like I said, a lot of these developers won't require you to pay them any additional money. MIT license is free, but you it's just such a pain. But I mean, from writing code, the documentation is like the worst part. But that's the same way with the contracts. You got to document it all, and it'll just be such a relief when you go back later and have to pull this all out. The other thing is too, when the acquisition company comes in and sees what you've done, they're going to appreciate that you know what you're doing, and probably not going to be as red flaggy as they would normally be.
Oh, definitely. Well, I appreciate that. We do have a quick follow up on the about the name question. Uh, so they said it was about the name. They were also asking about, you mentioned a design copyright. They're curious if it's going to cover the general aesthetic of the game.
Uh, and would this be, you're thinking it's more of a board game or more of a video game?
That is a good question. Uh,
Okay, I can go through both. So the copyright, um, the crazy thing about copyright is that, and same way with trademark, that you have a common law trademark as soon as you start using it. You don't have to get a registration. You can sue somebody. You usually get the federal registration, gives you triple damages and attorney fees. For copyright, you have a copyright as soon as you fix it in a tangible medium. So as soon as you write the code, as soon as you do the artwork for the game, board game, you have a copyright. You can't sue anybody until you actually register it. So I would recommend that you register it as soon as possible. But the copyright would protect it's not going to protect something general, something like an idea or a concept, but it will protect if you have that board, if somebody copies that board, or somebody copies your cards that you have for the game deck, that's going to protect that. And then in terms of for a software program, it's going to protect the exact code. If somebody reverse engineers it and writes their own code, it won't protect you. And then from the video game aesthetic, when you have what's on the screen, it'll protect you from somebody doing something that would be substantially similar in terms of what's being portrayed on the screen. This gets into what's called cine faire, which means that you can't copyright something that would prevent anybody else from, doing a functional equivalent. So yeah, you can have this magical cat that eats watermelon. That would be a character that would have copyright on it. Or you could have this magical castle that has it floats on balloons and it's purple and it has red crosses all over it. But you can't protect a cat being in a story and a castle being in a story. You can't protect it being that broadly. And I was just talking to my legal assistant today, and getting into it a little detail in terms of it's a real continuum. I can't tell you where to draw the line. Some juries are going to say this is copyrightable. Some juries are going to say that's too esoteric and it's not going to be copyrightable. But it boils down to every component of your video game and every component of your um, board game that's not functional, that's unique, is potentially going to be protected by copyright, whether you have that registration or not. So, I mean, I hope that answers the question. And if they have a follow up, I'd certainly be more than happy to address that.
Great, thanks, Brett.
One other thing is patent trolls that could be a big problem. It's not any kind of a problem really for board games, but it's a very big problem for video games that people get patents and they don't make anything. So the definition of a patent troll is somebody who gets a patent, doesn't make anything, so you can't sue them back, and just goes after people for license fees. And typically what they do is they ask for a license fee that's just under the amount you'd have to pay an attorney to represent you. So if they sued you for patent infringement and you paid, an attorney $50,000 to represent you and you won, you don't get that $50,000 back. You're still out $50,000 and you spent 2 years fighting over it. So typically they'll say, just give me $30,000, and then you give them $30,000 and it goes away. And it's the hardest thing I do in my job is to say, hey, you probably have to pay them the money, because I mean, I don't know if I can get a better result for you than just paying them the money. And the bad thing is they use that as a war chest to go after more people down the road. Now, if there's something, a huge problem with the patent, or it's absolutely doesn't, our guy isn't anywhere close to that, then we'll fight it. But sometimes, I mean, patent trolls don't make billions of dollars because they don't know what they're doing. I mean, they make that money because they have it honed down pretty well. So, there's also what's called trade secret, and that's basically something that has value by virtue of the fact that nobody knows about it. So, if you have customer lists, you have vendor lists, you have some secret sauce, some like Google's algorithms, or eBay's algorithms. Those things are protected by trade secret. That means that you don't file anything. That just means you have procedures in place to keep it secret. New employees that come in, they sign a confidentiality agreement. They're not going to go use it somewhere else. It's kept away from just the general public. You have security procedures in place. And once you do that, then you have a trade secret. And trade secrets are a lot better than patents because they're free and they last forever. But the reason everybody doesn't just go with trade secret is if somebody else discovers it on their own, it's completely you can't do anything to stop them. So if they stole it from you, if they did some kind of espionage, you can stop them. But if they came up with it on their own, or basically what you do, I mean, you look at what you want the software to do, and then you write your own code for it, then that's not going to be any kind of a trade secret infringement. So trade secret is only good if something is not capable of being reverse engineered. I can write a patent. I can write some software code that you know replicates a search engine, but it's not going to be Google's algorithms, and so it's not going to be as valuable. They basically just rely on trade secrets to keep most of their algorithms because they don't want people getting a head start on what they're doing. We had cases before of like Atari. They got into a case where Nintendo was doing a thing where they had the lock and key, so their console had a key and then had a lock in it, and then the individual cartridges had a key, and you had to use them together. So they couldn't protect the games, but they could protect that software interface between the two. And then Atari goes and gets they go to the copyright office and say, "Hey, I need to look at the copyright registration," so they can see what the lock and key is, and then they can make a knockoff product where that interfaces with that lock and key. Obviously, that didn't pan out the way that they wanted it to pan out, but that is something that people do. And if it gets in a situation where, especially in the software arena for video games, it's really hard to determine if there is some infringing source code in there because you just don't have access to that. And obviously, any company that has any source code, that's the main value of your company, and you need to protect that with everything you have. Almost any company that works in this space, whether it's board games or video games, 95% of the value of your company is in the intellectual property, whether that's the employees that you have, or whether it's the software you have, or the trademark. So you really have to, I think these kind of situations are good. So you at least know what you have, so you can decide, whether you want to protect it. Because if you say, yeah, I could get a patent, but it's going to cost $25,000 to get it and $2.5 million to fight it, and I don't want to go that route. At least you've made that decision to go forward based on those grounds, and you don't have to worry about, uh, you know, having it hang over your head, not knowing what you should do. So learn what it is, decide yes or no whether to do it, reevaluate that every 2 years. And a lot of companies that come to me, I'll say, hey, you know, don't do this, don't do this. I mean, if you only have $10,000 and you have a choice between spending it on a patent attorney or spending it on a marketing team. I mean, you 100% want to spend it on the marketing team. I mean, it's not going to help you if you have the Hope Diamond, or if you have a safe and there's a lump of coal in it. I mean, you want to spend that money and get something of value. If someone steals it, that's fine. But if you spend all the money on a safe, it wasn't ever going to get off the ground or make any money to begin with. So, intellectual property is extremely important. And if it gets stolen, it could ruin your whole company. But if you don't have a company worth anything, so yeah, I mean, I think it's really good to get all the information on intellectual property and put it on the schedule and say, hey, in 2 years I'm going to do this, or 3 years I'm going to do this, or I'm going to have everybody sign confidentiality agreements for free so that I protect that as a trade secret, or I'm going to make sure that I use these trademarks correctly so that if I do decide to register it later, it's there. Or I'm going to make sure that I have all these assignments in place so that I always advise to do the super, super inexpensive things just so that you can hold off on making the expensive decisions down the road. Because again, you're probably going to pivot 3 or 4 times before then. And so your patent on your product that ends up, it isn't even going to be your product in 5 years. That's just money down the drain. So that's kind of a practical solution.
Yeah, Brett. Quick question for you: as an indie studio, when should you start talking to a lawyer? Should you start looking into trademarks or copyrights or something, just to make sure that your assets are protected?
Well, I mean, I think that's a great question, and I think that's the take home here is that I think you should talk to an attorney right away, an intellectual property attorney that has experience in that, and they'll give you a half hour, an hour of free time, and basically they'll just run down. Here's what this is. Here's why you would use it. Here's why it might apply to what you're doing. Here's what the cost is, and then a good attorney will put it on you and say, it's a business decision that you have to make. Do you want to spend 25,000 on it? Probably not. Do you want to spend, $1,000 on a trademark? If that's really what's going to be the forward face, and you want to make sure that you have that preserved early, that's maybe something you want to do. There's a lot of things the attorney can help you with too, to say, hey, go on Google Patents and try to find it. Do your own, super cheap patent search, because if there's a patent out there that would prevent you from doing what you want to do, there's probably a 50-50 chance you would find it. There's probably an 85% chance I would find it, but I don't know if it's worth, $10,000 for that difference. I mean, if I could tell you that I could do 100% guarantee that you're not going to have any problems, I would pay the money to have an attorney do it. But I can't search anything that's been filed in the last 18 months because it's all confidential. So I could look over every one of the 11 million patents and say, absolutely nothing out there to stop you from doing it. And then next week, a patent pops up that was filed 18 months ago and then stops you from moving forward. So the bottom line is, talk to an attorney as soon as possible. Don't spend any money just find out what your options are, how that might apply to what you're doing, and then make a business decision. I'm going to do that in 6 months. I'm never going to do that. I'm going to do that in a year. I'm going to do this once we have the beta version out to stop people from doing things. So you need to talk to them as soon as possible to find out what you want to spend and when, from your business perspective, what makes sense. Sometimes people do things, they file a bad patent. I mean, if you had 50 patent attorneys file a patent on your video game, guaranteed, unequivocally, no two of those patents would be the same. And not only that, no two of those patent claims that is basically the heart of your patent are going to be the same. So it's going to vary somewhere from a terrible patent that's really easy to get around to a very good patent, which is very difficult to get around. But some companies file these bad patents on purpose because to the average person, they see, oh, that's patented. They just go away and go do something else. They don't look into it and say that patent's not valid or it's very easy to circumvent, those kind of things. And from what you're talking about, some of those companies that just don't have the resources and they're just basically looking for something to scare people away because nobody can look at it for 18 months, so they can't tell for 18 months whether you filed a completely terrible patent for almost no money or you filed a great patent, for a ton of money. And if what you're looking for is that interim effect, that scare tactic, that might be something that some people may pursue. Um, so yeah, the question is, when to do it. And I would say do it immediately and then, revisit that on an annual basis or sooner if that's what fits in your plans. But because you can do it for nothing, I would say do it as soon as you can.
So, and kind of as a cost savings measure, I really appreciate that you're bringing up, the idea that if you have $10,000, you could spend it on a patent, but then you may not get the marketing. So, the lump of coal in the safe, that that was pretty powerful. I'll just say that. Along the ideas of just making sure you have something that somebody else may want. I mean, that's really the big thing. So when you're looking at your product, I guess what are some things that you would recommend looking into that would be that sign to say, hey, you should probably get this protected? Would it be through a conversation with an attorney such as yourself? And then on the other side, um, you know, what? We'll start there. I had another
Okay.
part to it too. We'll
No,
start there. Yes.
that's a very good question, and people always that's the main question people ask me is they bring something in and say, "Hey, should I get a patent on this?" And patent attorneys are the worst people to ask if you should get a patent on something because their answer is always going to be yes. I mean, because it's just more money for them. So, and then the thing is too, they don't want to run the risk of even if they're being totally honest and say that's a stupid idea, and then you don't get it patented, and then you lose a bunch of money. I mean, 30 years ago when people came into my office, I'm like, good idea, bad idea, good idea, bad idea. But this guy brought in this device, and I'm like, I actually spent a ton of money in that area. I know that area a lot, and that's a dumb thing, and I would never buy that. And I didn't say anything. I'm just like, okay, I'll just go do it. And that guy made well over $1 million on that product. And then I have people come in every day and they're like, hey, here's this thing. And I'm like, I would buy that from you today. That is such a great idea, and they never make any money from it. And so whether you should get it or not, really depends on what your marketing ability is. Some of my clients, very, very rarely, I have these clients that are extraordinarily good marketers and they make money off their inventions. And it turns out to be a very good idea that they have it patented so that they can stop knockoffs on Amazon from making what they have. But in terms of whether you should get a patent or not, you really have to look at, you know, the patent is a force multiplier. So it's not going to make you any money. It's just going to cost you money, but it is a force multiplier. So if you're going to make $10,000, that patent, might make you $20,000. If you're going to make 100,000, it could make you 500,000. If it's going to make 1 million, it'd make it 5 million. But $10,000 is probably a bad example. If you're going to make $10,000 off it, 100% do not get a patent. That's the only thing I can say right out of the chute. But so if you have a business model where you are actually going to see this revenue, you're going to see $500,000 annualized, or you're going to see, $5 million annualized, you definitely need to try to get a patent as quickly as you can. Unfortunately, companies, they don't really have that kind of foresight to know that they're actually going to see those revenues. And then all of a sudden the revenues start coming in, but it's already been out there for a year. So it's in the public domain. So you can't get it. So if it was me, I'm a small business owner. You know, I would say probably, if you're 100%, you have orders coming in or you have investors just falling all over themselves to put money into it, I think you need to seriously consider a patent. 90% of companies are not in that situation. So I'd say probably not get a patent. But again, talk to the attorney and find out what a patent is, how it would apply to what your invention is, and then how that is going to generate revenue for you down the road. And then based on that, you make the decision and don't listen to the patent attorney. Listen to your marketing team, listen to your development team, listen to the market, listen to investors. Those are people who are going to tell you. And if they tell you to get a patent or don't get a patent, don't listen to them. Listen to what they do, see what they do. And if they're putting a bunch of money in, then go get a patent. If they're putting a bunch of purchase orders in, then get a patent. But if they say, oh, I would buy that if it came out, I don't think that would be something I'd base getting a patent on or not.
Awesome. That's awesome. And we have one final question, and I think we're pretty close to wrapping up. So we'll see if anything else comes in. If any other questions come in as you're going through this,
Sure.
if not, we'll let you do your final words after that. So, as an indie studio, as just a small startup looking to get an idea out there, you have an idea. Um, how much time should you be spending looking at current trademarks, at current copyrights, patents, to see if your idea is original and if just to make sure you're not going to get sued?
Yeah, that's the $1 million question. I mean, if I had a business where I could say I'm insulating you from liability for intellectual property infringement, whether that be copyrights, trademarks, or patents, I mean, I'd have people lined up, 10 miles down, just ready to follow themselves, writing me a check. I mean, that you've hit it on the head. I wish I could do that. I wish I had it in my ability to do that. So what they can do is, from a trademark perspective, pick a terrible name like eBay or Google, something that means nothing, but after you've had it for a while, everybody associates it exactly with what you have in terms of that relates just to you. The worst kind of trademarks are generic or descriptive, like red for apples or apple for apples. Those are not protectable. They're not worth anything. The next level is going to be suggestive, where it's no dose. So you don't really know what it is, but once I tell you what the product is, you get that in your mind, and that's a really good one because the marketing people like it and the trademark attorneys like it. Um, the other one, the next level is fanciful, where it's arbitrary, and that's like royal for gelatin. Royal has a meaning, and you can't get royal for royalty, but you can get it in a different context, and that's a very valuable name. A lot of marketing teams don't like it because it kind of throws people off. And then the last one is fanciful, like eBay or Google. So if you want to not get sued, pick a crazy name that no one else has even come close to. Um, Marketing teams hate that, so they come to us with names. We can do a search. You can go to the USPTO, United States Patent and Trademark Office, uspto.gov, and you can search trademarks yourself and see if there's anything else out there like it. It's not going to be a perfect search because whether it infringes or not depends on sound, meaning, and appearance, not necessarily just the exact words. So it may not come up with the hyphenated version or a truncated version or a homonym, and that would still infringe. So that's how you avoid infringement from trademark. The way you avoid infringement from copyright is don't look at anybody else's stuff. If you came up with it yourself, it's not going to infringe anybody else's stuff, even if it's exactly the same. And then from a patent, you cannot know. The only way you can be sure you don't infringe a patent is you're doing something exactly like somebody did 20 years ago from an expired patent. And in your industry, that is just not in the realm of possibility. So you just have to do what you do. Try not to steal anything from anybody else, but you need to have a plan in place. The day you get that cease and desist letter, you need to be on the stick, because if you get that cease and desist letter and then you kind of store it away, then instead of getting sued for compensatory damages, what damages there are, you get triple damages plus attorney fees. So you need to have something ready to go the day you get that cease and desist letter, to have an attorney tell you you don't infringe or do this and you can avoid infringement. And here's going to be our responsive letter. You cannot let that sit for a day. You need to get on that as soon as possible. Is that just put a little
Yeah.
scare into you. So
Well, absolutely. I think one of the biggest things is, as a software developer, do not copy from Stack Overflow. Use it as a reference, right?
right,
Yeah.
right. Yeah, no, that's exactly right. See what they did and then write your own code. I mean, because again, the idea of what's on Stack Overflow
Mhm.
is not protectable. It's only that incarnation that they put out. So yeah, see what they did and then do it yourself. And you want to get as far away as possible from what they did, because again, you don't want them searching, coming in, and finding you liable for copyright infringement. The thing is, you got to be meticulous when you do it. You can't do a little bit, fudge a little bit here and fudge a little bit there, because if you get in that kind of a mindset, you're just going to go way over the line, and 3 years down the road, your company's going to be bankrupt because you just got sued into oblivion by some terrible, terrible patent attorney.
Wow, that's huge. Brett, I think we're right at time. Do
Okay,
you
well, I
have
appreciate it.
anything
It was
else?
fun, and like you said, I can't. I got some gamers coming in right now, so I can't answer the Stack Overflow questions right now. But I will definitely go back on tomorrow, and I will be answering all those questions. So if anybody has anything, because I really like working with small companies, and I like to do whatever I can for free, because hopefully they'll be somebody 2 or 3 years down the road, because you just don't there's just not that much money to spend on intellectual property right out of the chute. You just got to survive for 3 to 5 years, and then you'll actually start gaining some traction. So I wish I could give better advice, where there's some website you can go to, make sure you don't infringe anything, but that's the best I got. So I appreciate it. It was a pleasure. I thank you for having me, and I'd be more than happy to answer any questions people have on the Stack Overflow, and I'll get to that tomorrow if I can.
Oh, and Slack. But we should get a
Slack. Oh
Stack
no.
Overflow one of these
No.
days too. Just don't
Oh,
copy.
no. All
But
right, good
yes, no,
deal.
yeah,
So,
yeah.
all right,
For
yeah,
whoever else is on, yes, thank you very much. And Brett, this was amazing. This was, whenever I go into these presentations, I'm like, I have no idea what I'm gonna get. And actually, I took some notes this time.
oh,
Rather,
that's good. I appreciate it. So, yeah, no, so yeah, like I said, I should have said I'll be answering Slack questions tomorrow. And if anybody has any questions, just let me know, and I appreciate it very much. Um, and I think that was a great close that you had in terms of that final question.
awesome. Well, thanks everyone. Again, thanks, Brett. So have a great night. We'll talk to you guys later.
Great, thank you very much. Take care.